executive session, and we'll reconvene the BZA agenda. Next item is adjournment of the BZA. So I'll entertain a motion to adjourn. So moved. Motion and a second. All in favor, let them say aye. Aye. Okay. Now I'll call the meeting of the Jefferson County Planning Commission to order. Just received the package, and a chance to look at those. If you have any changes or additions to those? Being none, I'll entertain a motion to approve.
So moved, Mr. Chairman.
Have a proper motion. Have a second. Have a second. All those in favor, let me know by saying aye.
Aye.
All those opposed? Anybody abstain? Motion passes. And we didn't have any citizens' input for the planning commission either. So we'll move on down to item A under new business, variance of the Jefferson County, Tennessee subdivision regulation for lot width of setback for two lots of 1674 Tilly Road in Cabot by Timothy and Angela Lowry. Is someone here to speak to that? You would step to the podium, state your name and your address.
Tim Lowry, and that's 1674 Tilly Road.
And you're asking for a variance of roughly 25 feet on that.
Correct.
setback.
Yep.
Catherine, you had a chance to look at that. I've not seen your
I did.
notes on that.
As a variance from the subdivision regulations, you need to state the hardship that you can't meet, and therefore you're asking for a variance from that regulation.
Going across almost a ravine top and not enough property on the backside of it to really have good septic and sewer.
If that's his stated reasons, then that needs to be included in your motion for approval or granting the variance.
Can we amend that now, Ms. Baldwin? And be satisfied?
You can just add it in your motion.
Okay, we'll do that. Does anyone else have any questions about this?
Do we have a map for this one?
Yes. It should be the front one.
It's actually a
Packet for planning. It's got the, that's it in your.
Wow.
Yeah.
plan.
Sorry, I had.
So you're needing it for septic?
Yeah, they got more room up front than you do have in the back. Time you get a house on it in the back, you'd have to pump it back up the hill.
That's always done that.
And there's one existing there, won't add another beside of it.
Correct.
Yeah, it'll be 150 foot is what it's supposed to be, and we're wanting to cut that down 25 foot on these roads.
I make a motion to approve due to the hardship of the septic system, the variance.
Okay, we have a proper motion by Randy Bell. Do we have a second?
I'll second.
We have a second. Any more discussion?
I have a question. Is it okay to ask a question?
Yes, ma'am. We will have to vote on this, so
Okay.
this will be part of the discussion though.
Okay. Is your variance the width of building setback? Because your width is,
There's no water on this property, so I remember you have to be 150 foot wide, it's setback
okay,
without water.
okay.
So that's why.
So that's the issue, okay.
Yeah, and he's at 124 and change, and I think 107
127.
on one.
Yeah, yeah.
Does that satisfy you?
Mhm.
Yeah, okay. Any further discussion? All those in favor of approving the motion, let me know by saying aye.
Aye.
All those opposed? Motion passes. Thank you, sir.
Thank you.
Moving down to item B, final plat approval for 3 lots off Muddy Creek Road damaged by Sharon Chester.
I've not heard from him.
So there's somebody.
It's the one. on here. This one
Okay. Stephanie, she's not contacted you. Okay, I'll share this and, okay, that's what y'all want to do. She touched base with me about 6 days ago. I think that's correct, it was one day last week. And she said she was still have to go and get some more stuff done, if she didn't show up tonight. She hadn't. So, if y'all just want to postpone this one, I think it would be right her. Motion.
Mr. Chairman, I move to postpone item B to the November meeting.
Okay, we have a proper motion, do we have a second? Have a second. Any discussion on this? All those in favor of postponement of item B, let me know by saying aye.
Aye.
All those opposed, motion passes. Thank you, and I'm gonna pause you just a second, and, I'm gonna, just in case something were to come up, and, I might have to leave a little earlier than that if the reason arises. And, we have new board members, and this is the new year, and I meant to do this at the start of the meeting, we got carried away about moving on in business. But we need to elect officers and stuff for this new year that we have. So we'll need to elect a chair, a vice chair, and a secretary. So I'm gonna pause here, and I'm gonna open it up for nomination for chair of the planning commission. Mr. Bell?
I nominate Brian Morgan for chair. I think he does a fine job.
I appreciate that. Any more nominations?
Mr. Chairman, I move nominations cease.
Okay, nominations cease. All those in favor, let me know by saying aye.
Aye.
All those opposed, motion passes. We'll open the floor for nomination for vice chair.
Mr. Chairman, I nominate David Nelson for the position of vice chairman.
We have a nomination. Do we have any more nominations for vice chair?
Make a motion that nominations cease.
We have a proper
Second.
motion. Okay. All those in favor of David Nelson for vice chair, let me know by saying aye.
Aye.
All opposed, motion passes. Now, nomination for secretary.
Mr. Chairman, I nominate Ms. Sue for the position of secretary.
Mr. Springfield, do you accept nomination? David, I should have asked you that as well, but
That's okay.
If I am not able to no longer be on the committee, y'all would have to re-elect another secretary, right?
ma'am, at the time you decided you need to do something different, we would, in that next meeting, we would vote, nominate, vote someone in as secretary.
What if I decline?
She can withdraw her name from,
Withdraw her name from consideration, and we can.
Yes,
have a
I'll
forum.
withdraw my name.
Okay. Have any more nominations for secretary?
Mr. Chairman, I'll nominate Mark Chambers for the position of secretary.
Mark, do you accept?
Yeah, I'll accept it.
Do we have any more nominations?
I think I've used all of mine up.
And we nomination cease over here. All those in favor of Mark Chambers for secretary, let me know by saying aye.
Aye.
All those opposed, motion carries. Okay, we can get back on the business now.
Mr. Chairman,
Yes, sir.
question. What about a parliamentarian? Is this body ever elected a parliamentarian?
John Neal was the standing. I don't know if he had that title by name, but
Well, he was, of course, the county
he
commissioner.
was for county commission,
Right.
and he just filled those shoes with this board. So if it's the pleasure of the board to elect a parliamentarian, or appoint a parliamentarian, we can do that. Is that what y'all would like to do?
I'm fine with that.
Okay. Okay, we'll open it, back up nominations for parliamentarian. Do any volunteers for parliamentarian?
I'll do it. I'm still learning it, but I'm willing to They could try it, yeah.
Fair enough. Austin willing to fill those shoes. Will somebody nominate Austin for yourself?
I will nominate Austin Brooks for parliamentarian.
Okay, are there any more nominations? Okay. Being none, all those in favor of Austin Brooks serving as parliamentarian, let me know by saying aye.
Aye.
All those opposed, motion passes. Thank you, Austin, for taking that role on. Okay, moving on down the agenda to item C now. Final plat approval for Wooded Estates Phase 3, Lot 17, 17 lots, pardon me, off Laura Bowling Loop, Strawberry Plains by Daniel Stacy. Is anyone here to speak on their behalf?
He was in the office today, he was supposed to be here.
Okay. Him not being here and to be considered of our time and his interest, entertain a motion to postpone this.
Motion to postpone.
Have a motion, we have a second.
Second.
All those in favor, is there any discussion on that?
We're on item C.
Yes,
Right,
item
okay.
C. All those in favor of postponing item C to the November meeting, let me know by saying aye.
Aye.
All those opposed, motion passes. And
Item D was pulled.
D was pulled. So we move on to item E, final plat approval, 4 lots off Nancy's Ferry Road, New Market by Billy and Donna Train. They here. Okay. Okay.
My name's Billy Crane. I live at 4548 Cherokee Drive.
Paula, have you had the opportunity to look over these?
This one is plain.
Right, yes. The E and the G.
It says, Alex, nothing about Alex Moore.
I have 2 extra maps here if you just want to look at them.
He talked about one.
And I got one with all my signatures on it too.
Okay.
I did have a couple comments. One is there's an overhead power line that starts from the north side of the property. Depending on the voltage of that overhead electric, it needs to have an easement associated with it. And it is dependent on the voltage of the line, especially since that's going to be your front yard setback. I think that needs to be addressed. And then the signature block for the county road superintendent was omitted to certify that the roads are appropriately represented. So those were my only 2 comments.
Well, I know there's a power pole in the middle of one of these lots, but it's kind of, I mean, it's way away from the road. It's nowhere near the road.
Well, that's just it. It could be close. We want to make sure that no one builds a structure within a safe distance from it.
No. The house sites that's drawn on my map here are way away from the power pole.
It still should be within an easement. Are you going to build the houses? You going to construct the houses?
I'm going to deed these 3 1-acre lots off to my kids,
Okay.
and we're all going to have houses on it. There is an easement on the property already to access the back acre lot here on this map.
25-foot power easement.
Yep.
And I'll go ahead and feed on the power, that is a 76-foot line going through there, and it's 15 foot off the power line. Kind of common knowledge.
Oh, okay, yeah, I don't see any issues with any of that type of stuff.
The structure has to be at least 15 foot.
Oh, they're gonna be probably well over 100 feet away from that power line.
That's Appalachian, or, that would be Appalachian, they don't have right of way to get to their stuff, but the building just has to be 15 foot out. So, and you would like that stated on here?
It it should be stated, I never look at ownership or if they're creating legal lots of record. You can, any subsequent title holder could decide to move the house elsewhere,
Yeah.
and it's a safety issue.
Okay, and we need to get Joe's block on that and get his signature on it, so, okay. So, yes, Mr. Nelson?
I have a question, remember on you. I thought we had to have house sites shown on the plan.
We did.
Oh, we don't have it.
He's got, it's not on the small one that's here. He does have those on there where he has the signature block.
Okay, all right. Thank you.
That's, you're welcome. And that topic come along before we got ours. But good question, Dave. Anyone else have questions? Tommy, you got something?
What do you think about a house site? I got one comment.
Yes, sir.
I think a house site is ridiculous. Because when they do this, they're gonna apply for a septic, so where that house is will not work. So I don't know where to put a house site.
The reason for that, and you other members correct me if I'm wrong, is just so that there is ample space to build a house on that lot. And that was to protect the property owner from people who purchased lots and there was no building site on it.
Yeah, well, there again, a building site don't mean nothing if you don't have a septic. And the only place the building site can be is where the septic is. So, you know, when you put a house out on there, somebody buys it and say that's where that house is going to go, then I have to come back and tell them, say, no, your house isn't going there. Don't even come close to going there. And so, you know, I brought that up once before and never did get really a discussion. But since he brought it up, I thought it'd be a good time to maybe address it again.
I appreciate your time speaking to it. Okay, and I think we've got several comments here, so.
I know you have an amendment, this was the only thing I was considering, I agree with you, but you do have a requirement that you adopted in the Sudbury amendment.
We did.
That requires you to certify a certain square footage that has the appropriate grade for a house combination.
And there may be multiple spaces
Right.
on that lot that could accommodate that house. They just have to show that there is one.
Right. But is that what was done, or was the actual house location?
No, it was just to show that there was a building on the
So
lot.
that is, okay.
Yes. And correct me if I'm wrong, but that's, okay. That's where we're at, so.
Yeah, that was, my understanding was that you're showing that you do have an available house building site. But to Tom's point, if you have a house site and then you don't have the space for proper sewer and field lines, drain field, then you actually don't really have a building site, unless you have the ability to hook to sewer. So
Exactly right.
that may be something for us to consider.
That's something to consider moving forward, because we can't really do anything about that now, but it is a good discussion. It is. David, did you have something?
No, I'm fine.
Okay, so you can get the block from Joe on the roads, and you can go back and add showing 15-foot off the power lines. Utility.
So who do I need to,
Probably Marty Mills, so just talk with Marty.
is that the guy that's already signed mine?
He done
Already signed it.
he signed it.
Yeah.
And again, I hadn't seen the one you have.
Yeah, all my signatures, the 911, water, and power company's done signed mine.
Marty signed it. She was just wanting to show 15-foot, that line off that power line.
And it can be stated in the note section, so they don't have to delineate it, but they need to do one or the other.
So I need to take it back to Marty and have him put it,
Actually, I thought Mr. Garrett sealed the plat.
He signed it.
Garrett
Eddie
signed it.
Garrett
Garrett
is your,
stamped it.
so you actually can't, only Mr. Garrett, if he has sealed it, can make up any changes to the plat itself.
Right.
Take it to Eddie and have him make a notation on the side that there's a 15-foot utility easement for existing power lines. That's all you gotta do. Eddie can type it right in on there and then you can record it.
Just type it in on here anywhere? On
Just
the,
over in your notes,
oh, okay.
just on the notes side.
Oh,
of the
okay.
line.
You got a note section
Yeah.
there.
You can have her type it right in and then you can take it and record it.
You'll have to go by and see Joe and get that block put on there.
Who's Joe? I don't know who Joe is.
Highway superintendent.
Superintendent of roads for the county.
His office is right under.
Oh, he's under here?
Yeah.
Oh, okay. So it's all done right here once I get Garrett to put that in the notes?
Yeah.
Okay.
But we will approve, if we decide to approve, on the contingency of those two things being done. And then you can show that to staff then, and we come back in and get those things taken care of. Any other questions? Mr. Randy?
I'm just gonna make a motion to approve with those two
Contingency.
additions.
Okay. We've got, a proper motion, we have a second? We have a second. We have any further discussion? Being none, all those in favor of approving contingent upon the right-of-way on the power line and the signature block from Joe Patterson, road superintendent, let me know by saying aye.
Aye.
All opposed? Motion passes. Thank you. Chad seconds, did you not, Chad Dixon second. And then we're to item F on the agenda, site plan review for Love's Travel Stop, site expansion, 1058 Beach Range Road, Dandridge, by Love's Travel Stops. We have someone there, here's people that you take photos with.
Good evening, Commission. Brad Peck with Love's Travel Stops, 10601 North Pennsylvania Avenue, Oklahoma City. And then I have Sarah Harville with CSO.
175 Montrose West Avenue.
Is our civil engineer.
Ms. Baldwin, you had the opportunity to look this over to some degree.
I have. The site plan itself was not sealed by a licensed professional. Typically, that's an engineer. I'm sure you've got a professional engineer that will not prepared the document. I just didn't see his seal affixed to it on any of the pages that I looked at. I think there were subsequent pages, the size of your document didn't email well. So I think the ingress points were identified on subsequent pages. And I did look earlier, and my last item was to provide dimensions of travel lanes, and those were all on there. So the only one I had was prior to issuance of a building permit, and professional engineer seal should be affixed to the document.
Okay. Well, she's our engineer, so we'll get her seal on it.
Love to see women engineers.
Thank you.
Do we have any other questions or comments from the board on this site plan? I had a chance to look it over.
Well, I had a question about the ingress and egress there coming off of the ramp, off of either ramp. It really don't matter, but if you're headed west, at the end of the ramp, maybe approaching T-Dot, about a decel lane from there to the ingress and egress, if there's enough room. And the reason I say that, anybody that travels that road a lot knows that as the trucks back up in the evening, it's always a tail of the truck sticking out, and we're sitting in traffic. We're waiting, and there's the gas pumps, and it's like, then you've got somebody 20 cars back that kind of gets antsy, and then they're getting on the wrong side of the road, and we're coming up through there, and it's just a safety issue. I just kind of had it in my mind. I looked at it today, just sort of glanced as I went through there. Is there enough room on the state right-of-way from the end of the off-ramp to basically have a decel lane to be able to turn and make it to the ingress and egress without actually getting over in the county road? I mean,
Sure.
I don't know, that's just a thought for discussion.
Sure, and we can definitely speak to them on that. I would say that with the change in design here, that we have created an entry lane that almost can immediately separate the trucks from the cars. And so, currently as you come into the site, everybody just comes in together, right? And it's that real wide opening. And so we've kind of created a separation here now where the trucks will be able to come in, continue to pass over, and the cars will take that left and get it out of the way. And then if the truck doesn't need fuel, there's an additional access further north that they can pull into the property. They can also circle back and get fuel in that lane as well. So hopefully those new changes to access will alleviate that problem. But we could definitely reach out to TDOT as well.
Just a thought, I don't know.
Yes,
There may
sir.
not be enough room. There may be utility poles but it just looked like there might be enough room for a.
We will make that note, and we'll approach them and
Parking
see.
there too.
Sure.
Especially with all these extra parking places, some of the parking area.
Yeah, well, we try to keep them from parking on the ramps or anywhere to say, and with the additional property that we've acquired, and, we are taking this site up to 152 truck parking spots, so hopefully that will help alleviate the trucks wanting to park on ramps and side roads.
Right.
Mr. Chairman,
Yes, sir.
I move to approve item F contingent upon the seal from the licensed professional being fixed upon the document.
We have a proper motion, do we have a second?
Second.
We have a second, any further discussion on this? All those in favor of approving item F contingent upon the engineer's seal, let me know by saying aye.
Aye.
All those opposed, motion passes. Thank you. G has been pulled, Stephanie, correct?
Yes, that's correct.
Okay, so item G has been pulled from the agenda. We're going down to item H. And you should have in front of you a copy of the resolution amending the zoning resolution of Jefferson County, Tennessee to reflect and clarify jurisdiction, powers, and authority of the Jefferson County Board of Zoning Appeals and the powers and duties of the zoning office.
Mr. Chairman, members of the Planning Commission, and I'll apologize to your planner. She just got this evening, but I want to go ahead and, while she's looking at it, and kind of take you through why that's in front of you. The County Board of Zoning Appeals was involved in an appeal by East Tennessee Land Development regarding a use determination made by Tim Seals. A motion was filed. The case had been set for trial for November the 13th. We'd done depositions, et cetera. A motion was filed, called for judgment on the pleadings. I won't get into the specifics or weeds on that, but basically it says, hey, the pleadings are closed, X, we win. So the claim of East Tennessee Land Development was that the Board of Zoning Appeals in the resolution, which was drafted in 1998, did not specifically provide the Board of Zoning Appeals with the authority to decide that appeal or consider the appeal of Mr. Asbury of Tim Seals' decision. It was a very narrow ruling. They did not go on the merits. The court did not say the use is permitted. The court did not say it was not. The court said, hey, Board of Zoning Appeals, you didn't have, regardless. And I disagree with what the chancellor said. There's arguments for and against that particular decision, but based on that decision and based on his holding that the BZA did not have that authority under the current zoning resolution, which would have been drafted in 1998, regardless of what occurs after, whether there's an appeal or subsequent motions or whatever. I thought it incumbent on me to at least address the court's ruling by proposing amendments to the actual zoning resolution that must be considered by this body, and it's only for a recommendation which would go then to the regional planning commissions of the three cities, and then ultimately to the county commission with respect to whether or not they should approve that. So that is why this is on your agenda. I did not believe that I needed to wait 6 to 8 months to figure out if the Court of Appeals thought that the chancellor was right or the county and Mr. Asbury were right. That's why this is on your agenda. That's why these amendments are. I will do this however you like. I can go through each of those and discuss them with you and what that amendment does. You will note that the resolution attempts to address the powers and the authority of the BZA, as well as address the duties of the zoning officer, and it also talks about time, written notice, several of those requirements now that would be in there. The only reason I did that other than just simply addressing the powers of the board, were if you're going to consider the resolution, you're going to consider amendments, then by golly, you might as well consider trying to clean the whole thing up to clarify it. For instance, now, if this passes in the county commission, written notification will be required to everybody, to the person appealing and to the person whose use is being appealed. So it provides just kind of a framework. I just wanted you guys to know that it goes into more detail than simply the powers of the Board of Zoning Appeals. But I thought while you were at it, you might as well consider those things. You all can amend this. You can change this. I would ask, if possible, if it's possible, to get a recommendation tonight, one way or the other, whether it's amended or not, to at least start this process to get it in front of ultimately the county commission in November or December, assuming they have time to do it. So I will do it however you want. You will note also that several sections of the 1998 resolution have been deleted because, candidly, they no longer apply. For instance, the the zoning officer has zero to do with building permits, because we now, unlike we did in 1998, we have a building department, we have a building official. So anyway, those kind of things I just went ahead and addressed. I'm happy to do it either way, Mr. Chairman. I know that your planner is looking at it. I can field any question that you guys might have while she continues to review it. And if you all have questions or changes you want to make, I'm tickled to try to address that.
We'll open it up now. If anyone has questions, Mr. Drennan? Yes, sir.
Mr. Drennan, could you help us sort of paint a picture right now of where we are from the standpoint of determining permitted uses, irrespective of this new resolution?
Yeah, I can tell you what my position was. The chancellor, with respect to my position and the position of Mr. Asbury's lawyers, found differently. But it was my position that under the current resolution, especially under the sections called prohibited uses, that the BZA always retain the power to determine if a use is not permitted in a particular zone, to be able to determine if that use is permitted or not. My argument was, if Tim Seals had never made the determination, the board would still have the authority to determine whether or not a use was permitted. He didn't agree with that, and primarily it was based on two state statutes. Okay, there are two state statutes. One has permissive powers that a county legislative body may give the BZA, and then there's another section that says the BZA has those powers. Just so you know, okay, long and the short. There is a city case called Whittemore where, with respect to cities, the court found this way: all of those powers are permissive only, that their legislative bodies must give them the ability to do those. And see, to boil it down, the chancellor found that our legislative body did not give the BZA that authority. So as it stands right now, the BZA has all the other powers it has always had, except entertaining and considering appeals of the zoning officer regarding uses that may or may not be permitted in the zone, or actions the zoning officer may take. That's the status now.
And then, if you factor in this resolution that's drafted, that paradigm shifts. Is that correct?
Well, what it would do is, again, and I wanted to, since I was going to, my thought was, if you're going to address changes with respect to the powers and the authority of the BZA, then you might as well go ahead and address legislative changes since that time that don't have anything to do with this lawsuit. For instance, I think in either 2020 or 2022, there was a statute that was passed that had these three requirements. BZA had to have a chair, BZA had to do all these three things. And so I added those, which were not in the ordinance, which you all did anyway, but I added them in the ordinance, the resolution anyway. So it is a clarification to ensure that there is no question. 8 months from now or 6 months from now, if this is appealed and the BZA wins, it doesn't matter. We're back to square one. The lawsuit basically, in essence, kind of starts over again because the court says they did have that authority, so you would have that hearing. If he rules against us, if the Court of Appeals rules against us, at least it's been fixed. You see what I'm saying? So moving forward, you would have that power and authority regarding that. I want you to understand also, I inserted a paragraph which with respect to resolutions is very unusual in the preamble, and that is the second paragraph. So as a position of the Jefferson County Regional Planning Commission, the BZA presently has the power to hear and decide appeals from the decisions of administrative official pursuant to these statutes. And the zoning resolution, based on a recent decision from the Jefferson County Chancery Court, out of abundance of caution, the Planning Commission recommends amendments to the zoning resolution. That is unusual language to put in a resolution, but I wanted it for everybody to understand why that they're going to, because the County Commission will have the same question, why are we considering these amendments? So that's why that paragraph is in there. But if you have any questions and specifically about this, I'm tickled to try to answer them, or any amendments. If the planner, if she has, I'll do my best to try to answer them.
In terms of the county adopting the actions of the Board of Zoning Appeals.
What, adopting the BZA?
Right, the actions of the BZA in this resolution, or
Okay.
that section of the.
You're talking about setting out the powers of the BZA?
Right.
Go ahead.
Because that is set out in the enabling legislation of the Tennessee Code, it always preempts the local ordinances, and definitely one of those authorities is the appeal of decisions made by the staff, or in interpretation, and I think that's in the same section as appeals of decisions made by the staff, and also interpretations of the zoning ordinance itself.
13.7.107 and 13.7.109 were the state statutes that we argued provided, 109 really, 107 is permissive, but 109 we argued the BZA has that authority. The court, relying on Whittemore in another city decision, said they were all permissive, and that the legislative body had to specifically provide those powers.
No, I have further discussion, but I wanted to not dominate. Let others have opportunity.
The only other thing I had was on, and you basically stipulated the Tennessee Code verbatim, which is not what most zoning ordinances do. One thing about the BZA hearings.
Where are you at? I'm sorry.
11-14 is the next to last page.
You say 11.4?
Yeah, 11.4.
I got you.
That's 30 days.
Okay.
That 14 days is now 30.
Well, this is my question, and my question I had was the appeal, if I do it on the 14th day, my question is, would it be 45 days? Because the BZA couldn't hear it you with me, on the 15th day, it would be the 30th day.
And I guess what I wanted to make sure was that the BZA cannot hear anything without advertising a public hearing for that item, and public hearing has to be advertised 30 days ahead.
Well, a public hearing for zoning amendments.
Zoning amendments, or, well, not zoning amendments, it's for variances.
Well,
And also conditional uses.
Yeah, the time frame.
I think an appeal of the staff's decision does not require a public hearing.
I agree. So with respect to, if you're talking about my understanding is, if it's an appeal or contest with respect to the zoning official's determination, it would be 14 days.
Okay, so.
You see that? If I'm read that
So
again.
you're saying that a request to the BZA has to be received at least 14 calendar days ahead of time, but the notice in the newspaper is 30.
But is that with the appeal for the BZA?
Yes, I think so.
Yeah.
And it was changed by the legislature like in the last two legislative sessions?
In 2024, there were changes to the statute, but it had to do with action the BZA had to take, I thought, within like 180 days or 120 days after receiving notice of something. They had to take action on it if somebody raised something. I did not see or pick up on the 30-day requirement for, in other words, like, as I understand, how late is business added to the agenda?
Well, this was the first time I've ever added anything 48 hours.
I'm talking about to the BZA.
I usually, my deadline's the second Tuesday, and I put it in the paper the Thursday of that week. So my paper, it would have been in the paper
I'm not saying you're wrong.
it would have
I'm just saying
been-
I'm not aware of the 30 days. I am aware of the,
I know it is for municipalities.
I agree with that.
Which is not 30 days.
The legislature increased the time frame for notification by, within the newspaper, quite a bit.
I don't think you have to provide notice of a meeting for sure within 30 days. I think that can be 5. A public hearing regarding whether the county commission adopts an amendment to zoning is 15 days or 14 days for sure. They have to have 14 days notice prior to that. That's for the county commission to do a zoning amendment, unless that's been changed. I did not see that was changed in 2024. I didn't see that changed in the 2024 statute. Maybe, but I don't know.
And I sometimes get confused between municipalities and counties, so it may be a little bit different for county, but yeah, they did increase the length of time. Now, that may just be for municipalities. But we'll both check.
I think that, but what I would say to you is the legislature did change that in 2024. There's no doubt about it. Whether or not they changed that to a 30-day, I did not see that they had changed the notice for the hearing on a zoning appeal to 30 days. I may be wrong, but I didn't see that. I'll tell you what, if you're looking that up, that's fine with me. I think Mr. Nelson may have some.
Oh, yeah, go ahead, please.
Do I have the floor for one else? All right. What I would like to kind of talk through with this commission is not so much the specifics of this resolution nor the legal points, but rather conceptually where we are and where I think this is leading. When I read our zoning resolution, a prohibited use is prohibited unless the Board of Zoning Appeals determines it's permitted. That's the way I read our zoning resolution right now. If we take this as presented, that paradigm shift I mentioned a minute ago changes that approval authority from the BZA to the zoning officer. It specifically gives the zoning officer the ability to determine if a use is a permitted use. I am not in favor of taking that position. I think if we're trying to do what's best for our community, for the residents, I would much rather see a body of 5 people in the Board of Zoning Appeals make that determination on what is a permitted use rather than one individual. So conceptually, irrespective of specific language in this document, I think this commission, we're not the Board of Zoning Appeals, we're Planning Commission right now, needs to make that determination. How do we want this to happen in our community, and what do we think is best for our community?
To Mr. Nelson's point, if you all will look at the section 1, the last sentence, the zoning official is authorized to interpret the zoning resolution and determine the applicability of provisions of the zoning resolution. They do that all the time. Hang on one second, I'm going to finish. And it says, what yours says that I changed today that y'all don't have. It says, and the initial determination of whether particular use are permitted in the various zoning districts. Let me tell you how this typically plays out. Somebody calls and says, hey, can I do X on my property? The zoning officer is the first one on the ground and says, hey, look, no, you can't do it. Or, yeah, this is one of the 16 permitted uses in the zone, you can do it. So I changed that to say the initial determination. If I understand Mr. Nelson's concern, it is, he would prefer that to say of a use that is not permitted in the zone, rather than simply whether something is or is, whether something is permitted in the zone. I'm not married to either of those, okay? I just wanted it to be clear that the first person these folks are going to call to figure out if they can do or not do something is going to be the zoning officer. They're going to call the zoning officer 100 times out of 100. They're going to call the zoning office and they're going to say, can I do this? A lot of times, Stephanie and I will go to the property and say, that is one of the 16 uses you can do in A1, or it fits into the group of the 16 uses in A1, and then she notifies that person and says, hey, look, you can do it. That's typically how that starts. So if there's language that this body wants to consider in that, it doesn't matter to me one way or the other. To Mr. Nelson's point further, in every zone, A1 to I2, it has that prohibited use language. And it says, if this isn't listed in the approved uses, then the only folks that can determine whether or not it's permitted or not is the BZA. If it's a like use. I just want you to understand, and again, I'm not married to the language, but the first person that's going to be out there to try to figure out for these property owners what's permitted and not is going to be the zoning office. And so and the reason I even put that in there was to clarify that when they go out there, they're supposed to tell somebody, does it fit here, does it not fit here, so that person can take whatever action. They can appeal to the BZA, and they can say it is permitted. But again, that's why that language is, I did change that to say the initial determination. I understand Mr. Nelson's point. I understand what he's trying to do, and again, if there's language you guys have that's better than mine. I had to do this as soon as I could to get it in front of you, so I'm tickled. I'll look at whatever you want.
Yeah, Mr. Dinner, one other question relative to where we are right now, in other words, status quo, is the zoning officer's accepted procedure, the way I think you said it, to go out and determine if a use is permitted. Is that implied authority or actual? No,
they do. They, in my opinion, based on the current ordinance, the current resolution with the 1998 plus 2000 amendment, I think the zoning officer is the administrative official that would go out there to check on that if somebody calls in now. Yes.
And that zoning officer right now, you think, has the ability, if they see a use that's not listed as a permitted use, to notify that person that they think it is permitted?
I think you would have to, my personal opinion is the administrative official would have to say something, even if it is, I don't know.
Right.
It needs to go in front of the BZA.
Right.
To be totally blunt with you, if they said that, that wouldn't bother me at all. If they went out there and they said, it's not within one of the 16 categories, you're going to have to take this to the BZA, that's fine with me. I just wanted it to be clear, because though I believe they have that authority under the current resolution, I wanted to clarify that they could go out and do that. But however you all want to change it does not hurt my feelings one way or the other. Were you able to, go ahead, sorry.
As long as they're going with what is permitted.
Specifically.
Specifically, it's in the zoning guidelines.
Yeah.
So
It's black and white.
it's black and white.
I agree. But you're saying, I think, similar to what Mr. Nelson's saying, is that if it doesn't fall within that particular group or those uses, then you would prefer that the zoning officer say, I don't know, and to bring it to the BZA. That's fair. I don't have a problem. However you want to word that, go ahead.
The same use has come before the planning commission multiple times.
Yep.
Or it has
That's
come
true.
before the board of zoning appeals multiple
Yes.
times. And they've made a decision multiple times that is allowed.
If you look at past procedure.
Yeah, then a
If it's the same
precedent has
thing.
been set. But the clean way of doing it is if it's come up that often and it's repeatedly been approved by you guys, it should actually be amended as a permitted use in the
Absolutely.
zoning.
Sure, it is permitted then.
Well, but
But to clean the language
to
up.
clean the language up, it should be clearly stated. Now, one thing I'm a big proponent of is that the zoning ordinance is a living document. If you don't amend it at least twice a year to make corrections to get it closer to being authentic and the way it reads the way with a high degree of clarity, then you're not doing a good job of it.
And so if you all wanted to change that language, for instance, to say the initial determination of whether it fits within those categories or that use, is that what you're saying?
No, I don't like that language either.
It doesn't matter to me, however you want to do it.
Right, I mean, and I'm not trying to wordsmith the resolution right now. I'm trying to establish what this body wants to establish as far as procedure, proper procedure. My opinion on this is I would love to see our zoning official walk out to a piece of property that has a use going on. They look at it and say, oh, that doesn't look like one of our listed permitted uses. This is not permitted. I want them to have that authority. I do not want them to walk out there and see something that's not a permitted use and make a determination themselves that it is a permitted use. I want that decision to be the BZA. That's what I'm after. Now, words, how we word that in the document is another step in the process, but I think the decision that I'm after here is what do we want the authority to be? Who does the authority to make that decision lie with? The zoning official or the Board of Zoning Appeals? In my opinion, it needs to lie with the Board of Zoning Appeals.
And that's the way your ordinance is written now.
That's what we currently have.
That's what it currently says. One
But
thing that's...
practice, excuse me, I'm sorry.
No, I know what you're saying. One thing that is important to understand is how often uses change. They're culturally very, change a lot. I use as an example a video store. It used to be, you never heard of a video store, then they were on every corner in modern day America, and now they're gone. And that's been in the span of like 15 years, and you don't have video stores. So there does have to be latitude to understand that things do change, but again, if you use your zoning ordinance as a tool, it should be, it should be amended and to reflect the current standards.
So if you inserted not between R and permitted,
If you took your original draft and here I did it for you.
that's all right. Go ahead and just tell me.
And put the word not right there, that would fix it.
Between R and permitted.
Yes.
I
that would
agree.
fix it.
I see what you're saying.
All you have to say, the zoning officer has the ability to determine if it's not a permitted use. But not the
Uses are not permitted in the various zoning districts.
Yes.
I don't have a problem with that if you guys are good with that. That's up to you.
You don't have an objection to making that change?
So everybody understands, Section 1, 10.1, the last sentence.
Would you just read the amended, is that what you're about to do?
Yeah, I'm about to.
Okay.
The zoning official is authorized to interpret the zoning resolution, determine the applicability of the provisions of the zoning resolution, and the determination of whether particular uses are not, you're going to add not between R and permitted
Yes.
in the various zoning districts.
Yes, thank you.
That's fine with Matt, if y'all are good with that, y'all add that. But before we leave amendments, let's go ahead and, if anybody else has any,
Well, I have more. I'm
go
sorry.
ahead.
Under the penalties for violations.
Where are you at?
Oh,
Which section?
It's 10.4
I got
in
you.
your resolution, Mr. Chairman. There's a provision for a fine, and it says $50 fine per day. I don't know if that's a statutory thing.
It is.
Okay, so we can't make it higher because
Nope.
it's meaningless. I mean,
It's $50 a day, it's $50 a day per day. Y'all will recall that there was a constitutional amendment several years ago to raise that, and it was defeated soundly. And the reason is because you're potentially entitled to a jury trial for a $51 fine. Go ahead.
There is another provision that's allowed.
Go ahead.
The legislature enabled hiring an administrative hearing officer that appeals can go to. You do have to adopt specific codes for that, but they can fine $1,000 a day per event.
Does that cover the cost of the hire?
No.
That's meaningful.
I mean, that's.
Well,
And that,
Better off like we are.
I just wanted to make sure
I
that
understand.
you knew that there was a different.
no, if you wanted to create a new office. Yeah.
Thank you for sharing that. And I
Yes.
wasn't trying to make light of it.
Yeah.
Go ahead.
Back to this current procedure where Board of Zoning Appeals gets to determine whether a use is allowed or permitted or not. Should that be included in Section 10 where we're deleting?
If you look at, I added that, that's one of the
Oh, okay.
sections that I added,
Okay,
you all don't have.
I don't have it.
It will be after E,
Okay,
F will read as follows.
okay, all
The
right.
BZA shall further have all other powers and authority as described in the provisions of the zoning resolution. So, for instance, because I had the same concern, was to be sure that any other powers, including those that are in the prohibited uses, remain. So if you look at my new F, which you all don't have,
Right.
it will say the BZA shall further have all other powers and authority as described in the provisions of the zoning resolution. Then G will read as F used to.
Okay, all right.
Okay, so that provision, who's taking notes? Sorry. It will read that, but that's how F will read, and I have an extra copy of that. All that's just a catch-all. If for some reason we've missed a power, I wanted to be sure that it was inclusive, that if there's another power in the zoning resolution that you all have, that you maintain that power. And so I did pick up on that. I did change it. You all just don't have it. But that's what the new F will be, and my recommendation, and the F in your alls would become G, which would state the official actions of the BZA shall be the final decision and may be appealed only to a court of competent jurisdiction.
And I have a question.
Go ahead.
Is it possible, there's this state statute controlled, is it possible to have decisions by the Board of Zoning Appeals regarding permitted uses to go to the county legislative body for final approval?
It is not.
No?
Nope, not under any set of circumstances. They are not a Board of Zoning Appeals. I want you to take a step back here, and I want you to understand why that is, okay? No offense to our county commissioners. I love them.
None taken.
However, they're elected by the people, okay? Decisions of the BZA are quasi-judicial. You have to act like a judge. What the legislature did when they set this up is to make sure that elected officials are not on the BZA because they don't stand for election. Judges rule on things, and to be candid, and I understand the argument to the other side, judges historically cannot look over their shoulders. Now, that sounds weird, but if you're in my business, you have to understand that there are a lot of times judges have to do unpopular things that are correct and are legal and are the law. And that doesn't mean that your county commissioners can't be those people, but there is manifold case law that says that the county legislative body will not, cannot, and it will never be an appellate body for the BZA.
Okay, interesting. What this tells me, of course, is it takes away from the county legislative body the ability to control our zoning resolution. Because when the Board of Zoning Appeals, without county legislative body approval, decides a use is permitted, that's tantamount to amending our zoning resolution. Any other amendment to our zoning resolution must be approved by the CLB, I believe. So it's just...
I disagree.
Oh,
I understand why I understand your argument, but I disagree for this reason. Is that with the BZ, in other words, like you're saying that the county legislative body should be an appellate body over these decisions. Well, I thought that's what you were.
Okay.
That you're saying that they should have, that people should be able to appeal from the BZA to the CLB. I might have misunderstood that. I apologize if I did.
Yeah, no, I'm just saying that decision seems to me like should be also approved because it's determining what is a permitted use, which basically is amending our zoning resolution. By statute even, any amendments to the zoning resolution are supposed to be approved by the county legislative body. So it's almost a contradiction or something.
But again, the short answer is that that issue's been tried several times.
So we have to fix that, we have to change state law?
State law.
Okay. I'll work on it.
Yeah.
But in that, what you're asking is for them to have authority to
Consider the
adopt
BZ
zoning amendments, and then you're giving them authority to make judgment calls on the written letter of the code. So you're giving them both authorities. In this manner, the county commission and the planning commission recommends, county commission approves and adopts the zoning resolution.
Planning commission, I'm talking about the Board of Appeals.
I understand, but you're giving the BZA a freestanding body to kind of make the appeals to them. Otherwise, you're having the county commission hear appeals on their own actions.
Right.
Well, true.
So that's not,
It's a separation of powers argument.
Okay.
it is.
I understand.
I may understand that a little bit.
It's
it's
also
a-
surprising to
Thank you,
most
Catherine.
people
Yeah.
that the subregs, your CLB has no authority over
Zero.
subdivision regulations
Nope.
whatsoever.
Right.
None.
That rests solely with the planning commission to keep politics out of it. It's the best engineering practice.
Do we have any other questions?
Mr. Chairman, two quick ones. I just wanted to reaffirm that when we make a recommendation and send to the county commission, it has to go to the city commissions within the county first. However, they only have 30 days to respond or not respond before it can come before the county commission.
I believe that's correct.
That's my
That's been
understanding.
changed a couple of times, but I think that's correct.
That's my understanding of state law.
I have to take action.
Yeah. One more question. Do we need a public hearing for this?
Not for the planning commission.
Okay, thank you.
I'm not aware of any requirement. I ask you, planner, that you can, in other words, zoning amendments can actually have their genesis in one of two places, actually three. This body can recommend, the county legislative body can send you resolutions that they want to think about, and it's not out of the public, citizens can actually come to their planning commissioners and say, hey, would you all consider a change in the zone? So that's possible too.
And I think the staff.
That's correct. They can recommend. So there's different ways to do that. Again, I want to be sure that the changes that have been, as I understand, I don't think they were made in a formal motion, but they need to be. Go ahead.
Could we do it as amended?
Well, I think we need to state it for whoever the secretary is.
Okay.
Okay, well, before we move, does anybody else have any other questions?
Did you find out on the 30 days we talked about? Sorry, I couldn't,
It's hard to.
no, they changed it in 2024, but I didn't,
We need to give her time to research this right here, so we can.
No, because that doesn't.
it says 14 days though.
Oh, it does say 14 days, that's true. I haven't found it yet where it says 14 days. Why don't you just approve it on the condition that the county attorney determine what the state statute is on the timeframe for public notice? Is that okay?
Of the BZA actions. So my
It's
question would,
either 15 or 30. I don't think it's 14.
I thought it was 14 on
Now,
the
you
one.
may have a submittal deadline.
Okay.
So there's a couple different time
Yeah.
frames. There's a submittal deadline to get on the agenda, and then there's a time frame for a public hearing notice to be placed.
Let's do it this way then. Whatever motions you all make, those two amendments that we talked about, add pursuant to your planner's suggestion that with respect to, what is that?
And I'm looking at the time frame
I'm with
for
you.
advertising a public hearing on a particular.
I'm with you. It would be section,
And usually what you do is do a public hearing to advertise the agenda to be read. You don't do that.
Section
Have
11.
you ever advertised for variance or anything?
just the agenda.
But you don't do a public hearing notice on it.
Yes.
It's a notice, but it's not called as a public hearing.
I'm not aware that there is a,
It's a meeting though.
There may not be. for
I don't
BZA.
think there is a, with respect to the BZA. However, based on the concern, if y'all, I apologize, what section is that on the 14 days?
11.4.
Whatever motions are made to amend, if you all will simply add, if there is a day requirement, whatever that day requirement may be, that be added. So if it's not 14, I'm not aware, I'm just telling you guys right now, I'm not aware of a BZA public hearing, but your planner may know. I'm just, that's okay. So let's do this. If for some reason that date is different than 14, you all will just allow me to make that change, or that change can be made. Does that make sense?
Yeah.
Okay.
And all we're doing is recommending to the county. So
That's
it's
all you're
not
doing
like-
anyway.
Yeah.
We're not approving anything.
Correct.
This is a recommendation to get the city so they can get it to county commission. I only had one amendment voted, and that was not at the, what was the second?
It was F, the new F will read as follows.
Oh, okay, we don't have.
You do not have it.
Yeah, any changes that we have made.
It's not. The other one would be under section 10.
Section 10, Section 1, Section 10, Section 11.
Section 10, 11.3 is deleted and replaced with the following. If y'all will turn to the next page, it says, after E, the new F will read as follows.
Right.
The BZA shall further have all other powers and authority as described in the provisions of the zoning resolution. The new G will be what F was, which is the official actions of the BZA shall be the final decision and may be appealed only to a court of competent jurisdiction. That's the amendment.
Do we have any further questions, comments? Being none, what's pleasure of the board?
Mr. Chairman? We don't have a number. I move to approve this resolution, I move to recommend this resolution to the Jefferson County Commission with the amendments to Sections 1, Section 10, Sections 11. Do we need to state them?
Yes, I'll do it.
Okay.
The last sentence of section 110.1 would be changed to read as follows. The zoning official is authorized to interpret the zoning resolution and determine the applicability of the provisions of the zoning resolution and the determination of whether particular uses are not permitted in the various zoning districts. That's the first one. The second amendment will be,
Section 10.
that is section 10. The new F, the BZA shall further have all other powers and authority as described in the provisions of the zoning resolution. And the former F will just become G. And the only other caveat was, as we discussed, regarding the days on whether or not, if a public hearing is required, it will comply with state statute.
So moved, Mr. Chairman.
Okay, we have a proper motion. Do we have a second?
Second.
Any further discussion? Being none, all those in favor of approving item H on the agenda, let me know by saying aye.
Aye.
All opposed? Thank you, Mr. President.
And I'll prepare a clean version and get it to the secretary.
Thank you.
Moving on down the agenda to item H, update from the Public Service Committee regarding the C3 zone, wholesale warehouse commercial district, waiting to hear from the committee. Do we have anything?
Mr. Chairman, so this item was tabled, so whenever it does come back, it doesn't need to be on the agenda. We would just need, whenever Public Service gets back to us, we would need to make a motion to bring it off the table for discussion. So,
Those of you that Bob and have heard anything from?
We've not met.
Not
I
yet,
don't believe.
So it's tabled, no need to take any action on it. Do we have any other business? Yes, sir.
I apologize in advance for continuing to dominate conversation today. I have a couple of items I would like to discuss, but I'm perfectly willing to postpone those to the next meeting. And that would be these two things. I'd like to discuss the rules and procedures of this commission, and I would like to discuss updating our underlying documents. Just to be added to the agenda for the next meeting.
Underlying documents, take those specific documents you need.
Subdivision regulations, zoning resolution, and any rules and procedures in writing that we may have that I can't find.
So anything on the zoning resolution that wasn't discussed tonight, would be that we just recommend that.
Right. It's just a general discussion about updating those.
Okay, so, being so willing to wait, is there any other business?
Mr. Chairman, on the rules and procedures, it's my understanding this body doesn't have specific rules and procedures that we're operating under Robert's Rules of Order. Is that everybody else's understanding?
It's just common Robert's Rule of Order.
Okay, so, but I believe we do have the ability to give ourselves rules of procedure, right, as a planning commission?
Yes.
Yeah, okay. Okay.
I got some legal advice on that, we do.
Thank you, Mr. Chairman.
Okay, anything else?
Motion to adjourn.
We have a proper motion, we have a second. All those in favor, can let it be known by standing up.